Often people hear the term negligence and they get scared. So let's dispel the myth. One of the most common types of personal injury causes of action is negligence. Negligence occurs when someone fails to exercise ordinary care. In most personal injury cases, the plaintiff alleges that the defendant was negligent. Sometimes when the defendant believes the plaintiff was also at fault, the defendant will allege that the plaintiff was negligent. So how do we prove negligence? Well, in order to be successful on a negligence allegation, the injured party must prove 4 elements. They are duty, breach, causation, and actual harm. Each one of these elements must be shown by a preponderance of the evidence, which means more likely than not. The first element of a negligence claim is duty. The duty that an individual owes depends on the circumstances. Normally, though, every individual has a duty to act as an ordinary and prudent person would under the same or similar circumstances. Examples of acting as a reasonable person would under the same or similar circumstances includes stopping at red lights and stop signs, using headlights at night, and just driving the speed limit. Once it's been established that an individual owed a duty, the plaintiff must prove that the defendant breached that duty. Breach occurs when the defendant fails to meet their duty. In order to determine if a breach has occurred, a jury is asked to determine whether a person of quote-unquote ordinary prudence under the same or similar circumstances would have acted the way the defendant acted. For example, a reasonable person would not travel 90 miles per hour if the speed limit was, say, 60 miles per hour. Now, on to element 3. A plaintiff can only recover if the plaintiff shows that the defendant's actions actually caused the plaintiff's injury. There are 2 types of causation, actual cause and cause in fact. We discussed these in another video that get quite in depth, so I'm just going to touch on them briefly here. Let's move on to the 4th step, which is damages. A jury cannot compensate a plaintiff if there has not been any type of actual harm. Harm, or damages as we call it, can be shown through proof of economic or non-economic losses. Possible damages in a personal injury case could be medical bills, damages to your car, lost wages, pain and suffering, mental anguish, disfigurement, impairment, etc. If you have any questions about negligence, causation, anything like that, feel free to check out our other videos, or you can always read our blogs online at warriorsforjustice.com. Thanks.